We are here today to talk about the uptick in immigration enforcement, which particularly is going to affect the hospitality industry. I'm Catharine Morisset. I'm a partner with the law firm Fisher & Phillips. Fisher Phillips is a national law firm, and all we do is labor, traditional labor, and employment, which includes immigration, which is one of the things we're talking about today. But we handle everything from an FMLA issue to a discrimination issue to a wage hour classification issue, do you need to pay somebody overtime or not, to I-9 audits and investigations like this. And with me is Davis Bay, who's our regional managing partner. I'll let him introduce himself in a second. What are we going to talk about today? Well, we're going to first talk about today's regulatory climate, which is going to explain why we think this is so important for all of you in this room to hear. If, of course, you agree, because that's why you're sitting here. I love to have an audience who's happy to learn the information we have to give. We're going to talk a little bit about what happens when ICE comes to do either a search warrant, an I-9 audit, or investigation. And remember, these are people who show up with guns. So telling them that they can't have a copy of something is probably not the way you're going to go with that. And then after we've scared you a little bit, we'll talk about preventative strategies, which is everything from being able to do I-9 audits and compliance on your own to talking about discrimination claims when it comes to folks who are documented and from other countries who are working here. The one statistic that Davis wanted me to pass out to all of you is that the head of ICE has promised that he will be increasing the number of audits ×4. Now, they have to hire more people to do that, but they have to budget for it. So that means we have a government agency saying that they want to audit 4 times as many of employers as they've already been auditing. And remember, the past couple of years, we've seen an increase, right, Davis?
Yeah.
With that, I'll turn it over to Davis.
So welcome to your 6-hour presentation on how to do an I-9. No, I could squeeze this down. The I-9 form is one of those funny forms in that it's a 2-page form that has 70 pages of instruction. There's something wrong when the government could, create this kind of complexity. But if you go back 8 years ago, no one cared about the I-9 form. It's been around since 1986. And if you say, did you do your I-9s, you kind of go, yeah, I think I did. But then when Obama came into the office, he said that he is going to enforce immigration through the employer, and that's a big change. Before, worksite raids were really about removing criminal aliens. And what we have with the Trump administration is that it's coming back the other way. Now, you could probably guess as an immigration lawyer, I have certain opinions about the administration, but as somebody who works with employers from all over the country, the first presentation I gave after Trump was elected was in Orange County. And I looked at an audience of about 350 people and I said, a third of you are absolutely thrilled, a third of you are terrified, but most of you are probably sitting in the middle going, let's wait and see what happens, we don't know. But what I said everyone has in common is that we all want a good workplace, we want a compliant workplace, and we want to support our employees. But what we've seen in historical terms is what I'm going to show you now, is why you should care about what it's like to be audited by ICE. So we have criminal arrests that happened within ICE, 452 last year, of which individuals who are responsible for I-9s can be prosecuted. 179 of them were owners. And remember, this is a trailing statistic. The litigation still goes on. I had a case where an accountant ran a farm. And this is my own case, where they brought me in after ICE was involved. And what he did was, because he had a farm and things were going to rot, he knew he had some people who were undocumented. He was told to fire. He fired them, then he paid them under the table to come back. His own managers took pictures of what was going on, and he was given a choice: pay $1 million sanction or go to jail. And he paid the sanction, but it affects his ability to ever get a loan again. It affects his ability to run his business. So these are real consequences, and that case was about 6 years ago. In addition to just the personal liability of the financial element, especially with this administration, we are now dealing with the idea of, are you harboring a foreign national? Are you potentially aiding and abetting their discovery? And this goes into issues of possibly moving someone from a regular employee to a contractor. So there's lots of pitfalls when we're dealing with ICE. So I want to make this relatively Q&A. This is a small enough room to do it. We're going to try to watch our time, and we have 15 minutes at the end, especially when we get to the part of actually completing the I-9. I don't want to lose people. If people say there's a term they don't understand, just let me know. But these are the statistics recently for what we've seen in the administration. This is the Obama administration in terms of sanctions. And again, these are all trailing statistics. I recently had a case in Texas, and I do this work nationally, where the employer was doing their I-9s wrong. They did the same mistake every time. They did them remotely. And of the I-9s that they had, and I think there's about 70 of them, they got $75,000 worth of sanctions for the same mistake over and over again. So it's not about whether you do the forms terribly, it's about whether you have a flaw in the system. So it's systematic failures in terms of your I-9 process. And you can see that the notices of inspection continue to go up. Catherine's absolutely right. ICE has declared that they want to quadruple the amount of inspections, not necessarily under the same pretense as the other administration in terms of enforcing immigration through employers, but also to remove people from the United States or put them in deportation proceedings. And those sanctions speak for themselves. So where do ICE investigations typically happen? There are a few factors. First of all, public safety is absolutely a major consideration. Transportation, I had a foreign national who was wearing a turban, a civil engineer, hanging around the Grand Coulee Dam, taking pictures. He was investigated because you have a situation of public safety. They didn't know what his status was. It was kind of an interesting situation. He was fine. But when we're talking about ICE investigations, hospitality is way up there in terms of areas where ICE likes to investigate. And there was an interesting phenomenon that I saw where I had a little restaurant on Chuckanut Drive where ICE wasn't investigating the biggest employers like GM or Ford. They were investigating the smaller employers because that's where the sanctions would be easiest to obtain and that's where the employers were least educated. So this poor guy was in the 70s, half blind, and he was given a sanction of about $45,000 or $50,000 because he was hiring part-time students from this high school. And he said, they gave me a social security number. I assumed that they were current. And the sanctions were so big, he goes, there's no point in me running this business anymore. I might as well close. So we were able to lower his sanction, but that is the attitude of ICE, is that they will sanction you, they will try to get you to correct your behavior, but you really have to fight to lower those fines down. And we're going to talk about a few ways to lower that down. So you have hospitality, you're a target. You also have Washington State. We were the first state to sue Trump after the travel ban. We are not favored by Jeff Sessions. California now has sort of taken a leap ahead of us. But we have to be really careful in terms of where ICE is going to send their enforcement actions. And I do believe Washington State, you're going to see a lot of it. So let's talk about some of the things that we expect. First of all, who here is responsible for the I-9s in your locations? Okay, so you have a lot of you who are not involved in the I-9. So let me just go back and explain what the I-9 is, and I apologize for the repetition. The I-9 form has been around since 1986. It was the first time that the government said that the employer is responsible for verifying the information that someone provides to show that they have the ability to work in the United States. And then it just sat dormant until about 8 years ago when Obama said, okay, we have this law, we should use it. And his first year, he sent out about 500 notices. By the time he was done, the last year he sent about 4,000. It was highly effective. On top of that, we added something called E-Verify. Now raise your hand if you know what E-Verify is. Good. Let me just define it again, though. What it is, it's a free system by the federal government where you could verify the I-9 information through a database. And typically, it's Social Security and immigration. That's all it is. When it first came out, there was a bunch of lawsuits to stop it from going nationally. I guarantee you that at some point, we're all going to be responsible for E-Verify. But how the states implement the laws to protect workers gets a little complicated. So E-Verify, you have the same requirements as the I-9. You take the information, and in case of E-Verify, you have to get the Social Security number on the I-9. That is the one major change in terms of the completion of the I-9 form, is that the Social Security number is no longer optional. You have to have it in there. So they can verify that information. Less than 3 to 5% of the time, you get something called a tentative notice of non-confirmation, and that just means there's something wrong with the data. Probably most of the time it's because someone entered in the data wrong. And most of the time it's pretty easy to complete or fix. But E-Verify is popular on both sides of the aisle. It's just that we haven't had a legislation to go through and make it mandatory. Yes?
Can you do that though before you hire somebody?
You cannot do it before you hire somebody. There has to be offer and acceptance. Yeah. So let me go back to another part of the I-9 form. I was going to get into this when we get into the I-9 form. The I-9 form gives you information that could be used for discrimination, so you cannot execute the I-9 form or E-Verify until there's offer and acceptance of a position. But what's going to end up happening is that if E-Verify becomes mandatory, employers are going to be confused, just like when they first got the I-9 form. When people first started doing the I-9 form right, they made a mistake. They were doing them incorrectly. And then in the process of trying to correct the I-9 form, they just compounded the error. So let me give you a taste of something that we've seen already, which is California. And a lot of our law comes from California. A lot of what we do goes back to California. In California, if you use E-Verify inappropriately, it's $10,000 per instance. So think about an employer, 100 employees. They go, oh, we have to do E-Verify. Let's just go ahead and re-verify everyone we have. You can't do that with E-Verify. Unless you have a federal contract that requires re-verification, you do not re-verify people on E-Verify. And I guarantee you plaintiffs' lawyers are paying attention to this. Because that 100 employee company just offered themselves up to $1 million of sanctions. So you can see how implementing these rules are really important. Obviously, some of the predictions that came up with the administration and the campaign trail was that they were going to tighten up the security at the border. We're already seeing a decrease in immigration anyway. I don't know if the wall is really going to be a very effective tool to stop people from coming in. But in any case, we are seeing at least an increase in number of the arrests. We're not seeing an increase in the number of deportations. We've already seen that DACA is canceled. Who here is familiar with DACA? Okay, not everybody. Anyone hear the term dreamer? Okay, dreamer is essentially the same thing. The DREAM Act has been around for 20 years. No one was able to pass it. But the effect of the DREAM Act was to protect people who come in as children who have no criminal record, otherwise an upstanding citizen or person in the United States. And then at this point, we have to figure out what to do with them. 800,000 Dreamer EADs were approved. Now you take the population of the United States, about 350 million. You take the number of people who are actually working in the United States, about 230 million. You start seeing that about 1 out of 250 or 260 people are on this EAD card, this work authorization card, employment authorization document. And that's what the DREAM Act did, and that's what was just canceled, was that it gave these people work authorization and protection from removal. And right now, we're trying to see if Congress will step up and pass something that will take care of these people. But if you think about 1 out of 260 people, that's a significant portion of the workforce. And probably a lot of people in hospitality. Executive orders versus executive actions. One is law and one's a wish list. Executive orders are law. Whether those orders are constitutional or not, that's up to the court system. And what we just saw with the last executive order for the travel ban is, again, it was struck down by federal court. There are lawsuits about the cancellation of DACA as well. We're going to see how that goes on. This concept of extreme vetting. Anyone here actually do visa applications? About 70% of my work is just getting people temporary visas and green cards and such. The process of getting a green card or temporary visa in the United States is just going to get harder and harder. The latest thing now is that they want to know all your social media handles for the last 5 years. Okay, how many of you opened an Instagram account and never thought about it again? Right? LinkedIn, you know, we use that a little bit more, but I mean, how many social media accounts are there that you could do? Well, that's what you have to show now if you're a foreign national getting a visa at the consulate. So you have to recognize it's hard to be an immigrant in the United States now. And we put them through scrutiny that we don't do with anybody else. Here are a few more predictions. Green card applications are going to take longer. They're going to be slower. There are some wonderful people who've come to me and saying, I have a dreamer or I have somebody who I'd like to get status in the United States. 90% of the time I say there's nothing you could do for that person right now. Under the current legislation, there's not much we can do. But I'm always happy to talk to people about that. There is this general hostility towards hiring foreign nationals. It goes back to another executive order about hire American, buy American. And the idea that the process of getting temporary visas like the H-1B, which is one of the more well-known visa categories. The head of Microsoft, for example, Nadella, was an H-1B holder. Well, those are going to stay there in terms of the same quota, but getting them is just going to be harder and harder. And last year, when we filed H-1Bs under this lottery system, 45% of them came back with requests for evidence to say, we want to see more information. In previous years, it was closer to 10. That was an immediate effect of the administration. And this is the one that we're going to talk about today, the idea that audits are going to go up. So the head of ICE, as Catharine said, is the person who said they're going to quadruple the number of hiring. The problem is they have 2,000 open positions before Trump took office, and they have now the allowance to hire another 15,000. But they aren't hiring anybody because people want to get involved in like sex trafficking defense and other things. They aren't looking to do I-9 audits. But that is the direction of ICE. So we're going to talk a little bit about what a notice of inspection is. They're going to come in, usually with their ICE vests on, guns. They're going to ask to see your documents and offer you a search warrant. Now, some employers who aren't prepared for this are simply going to say, come on in, take a look, talk to whoever you need, because they're rather intimidating. What you have to know is that you have rights, and that's something that our firm says all the time. Employers have rights. You should have a protocol for when they come to you, especially if you're a smaller hotel or a smaller restaurant and you don't know what to do. You should have a protocol about saying, okay, this is who we call, this is where you allow them to sit. If you let them walk around and talk to everybody, you've just opened yourself up. You say, please sit in this conference room or sit in this room. We'll call our attorney or we'll call our advisor, we'll find out what's going on. But you have 3 days to turn over your I-9s. That is not a lot of time. They will ask for everyone typically who is currently employed by you. They could ask for everybody within the retention period of the I-9, which I'll get into in just a minute. The review can be done at the employer's location, and this is where I get involved quite a bit, is someone says, I got a notice of inspection. So then I start ghostwriting things for them. I start saying, ask for these things, like ask for an extension. Ask that we can move or mail the documents or come to you rather than you coming back to us. Find out who you're working with in terms of the inspector so I can find out if that you have someone who's pretty flexible or not. Our jurisdiction is pretty tight. We're not super friendly. You can turn in the originals, but make sure you get receipts for everything, because if they say something isn't there and you know it was there, you have no backup on it. So I would make copies of everything you submit to ICE. And again, you have the ability to ask for a representation at an ICE hearing, ICE office. There's not much we can do other than making sure that their requests aren't going beyond the scope of what's required. So the new I-9 form, as everyone knows, there was another one that came out, but it's for November 6, 1986. That's when IRCA came out. That was the law that was created to require the I-9 form. These are all the documents that could be required, including corporate information. Information about what's required. Sorry, I'm just checking the time to make sure. What's required in terms of the employer. It can include things like who's in charge, who's the manager, who's the owner of the business. So if you're a passive owner of a business, you have a very good reason to ask for this information. As I said before, you have a 3-day period. You can ask the people to not go back into your location, not intermingle with your employees. The hardest part about this is the optics to your employees. It looks like a raid. And if you go back and you have your employees and they're already nervous, or they have family members who may not be documented in the United States, even though they are protected, this is a scary consequence. And we have seen where an ICE audit leads to their home. What's really upsetting is they see someone on DACA. They're like, then where are your parents? What rights do you have as an employee to protect your family? Yes.
First you said it's 3 days notice required. The last slideshow you showed was not 3 days required. It's a bit of search warrant.
The search warrant is what's handed to you that says you have 3 days.
But it says 3 days, no 3 days notice required. What does that mean? The first sentence, no 3 days notice.
Oh, you know what this might be? There's a notice of inspection, but then there's actually a search warrant. A search warrant is a little different. I'm sorry. I should clarify this.
Yeah.
There's a notice of inspection, which is a warrant of inspection.
Right.
Then there is a search warrant. This is becoming a little more common, where they actually say, we want to search your facility for a criminal alien. If it's a search warrant for a criminal alien, then it's different.
See.
My apologies.
I have a question on that.
Yeah.
So a search warrant, would that typically be only if there was some information that they may have received that they want to come into the workplace, or is it just going to be random? I wouldn't think they would do that randomly unless they have some particular information that leads them to do it.
It's usually some kind of criminal investigation. On occasion, it comes out by phone calls. There's a hotline number that you could call. I did have an interesting situation with the unionized labor workforce where they wanted to really get at somebody who was blocking the union, so they kept calling saying this person's undocumented, this person's undocumented. Eventually you call enough and it might give rise to an inspection. The hard thing with the administration that they're doing now, though, is Obama, I don't know if you knew this, deported more people than any president in history. And the reason why is he really focused in on criminal aliens. And when you have criminal aliens, it's easy to get them removed, but now that you're spreading the net so wide, they're doing a lot of investigations, they're doing a lot of arrests, but you can't get them through the system to get them removed because you don't have enough judges. They still have rights to hearings.
And then are you finding that if you participate in E-Verify, then your chances of getting the notice of inspection are less? Or is this
No, actually, the question is, if you do E-Verify, are you lowering your standards for getting inspection? The answer is no. What you're doing is you're lowering your fine expectation. Yes?
Are you recommending that we do engage in E-Verify?
That's a great question. So up until a few years ago, I used to say, if you don't have to, or you're not prepared, you probably don't want to, unless you're required to by a federal contract. What I say now is, if you have the capacity, it adds about 15 minutes to every hire. The system is better now. But if you post that you do E-Verify, you may have a hard time recruiting people too, especially on the eastern side of the state. So my recommendation is evaluate your hiring ability before you sign up for E-Verify. Make sure you have the ability to manage E-Verify correctly, because it probably will become mandatory and you may want to get ahead of it. But it doesn't lower your chance of getting an investigation. Okay, so this is what happens when you get the notice of inspection. The first thing they do is they tell you, we looked at your I-9s, and it takes like 6 months right now in our jurisdiction to get this response back. It says, we've looked at your I-9s, and these are all the technical errors that we want you to correct, and you have 10 days to correct it. This is the things like not putting in someone's phone number on page 1. Then you have the notice of intent to fine, where they actually tell you, these are all the mistakes you have, and this is how much we're going to fine you. And possibly with that document is a notice of suspect documents where they say, and here are all the people we believe that are not legally in the United States. We want you to have them either come back to our offices for review, or we're going to come out to your work site. Obviously, you don't want them coming out to the work site. Notice of discrepancies, again, is part of the notice of suspect documents where they say, these are the things that don't make any sense. This social security number doesn't match this person's name. If you do well, and we're talking about less than 10% error rate, you might get a warning. The typical error rate is about 50%. If you have the typical error rate, you're going to max out your fine level, which I'm going to get into in a minute. So this is where I frequently get involved, is after the notice of inspection and then when I have to negotiate. That same client that had that large fine in Texas, about $75,000, we got that lowered to $15,000 over 3 years. There are massive amounts of negotiation that can happen through an ICE investigation. How do you establish what the penalty will be? Well, there is a matrix, a formula that they use, but these 5 factors, good faith, seriousness, whether the violation involved unauthorized workers, in other words, whether you should have known that someone was undocumented, the size of the business, history of previous violations. If you're a repeat violator, you could get 3 times the sanction. And then the idea here of good faith, that's where E-Verify comes in. That's where you will lower your sanction by 5% just by doing E-Verify. Or if you get the fine, you could ask for that 5% because you already do E-Verify. This is what's changed recently, and it changed really recently. See those numbers, 110 to 1,100? They just doubled. So where you previously had an expectation of $110 per simple violation, now you can expect about $220. And this is how they calculate it. It is not based upon the number of errors per se per form. It's based on the percentage of fail. So let's take 100 employees. 50% on average are going to be wrong. You multiply that by 210. Well, you have a certain number, right? It's not too bad. But then you start getting to if 50% or more are in violation, and then double that number because that just got doubled. Your sanction is massive. It's well over $100,000. And that's if you're just average. I expect this to come up more often about whether an employer had knowledge that someone was undocumented or not, simply because the Department of Justice is so aggressive. And the idea of, let's say you have a hotel, and let's say you provide them transportation to work. Are you transporting people who don't have documentation? There was a church in the southeast of the United States who was transporting their members to church. And they tried to investigate them for illegally, knowingly transporting people without documentation. They actually made the defense that this was part of their religious freedom, which was a really interesting thing in the Southeast to argue. It's like, wait a minute, religious freedom is a pretty good argument. So the I-9 audit does create significant financial penalties, but there are other things that it could trigger, and that's when I'm going to turn over to Catherine.
So this is where Davis and I have the chance to work together with what may be going on in the context of an investigation or where we're doing the training. So the U.S. Department of Justice is the agency that enforces some immigration laws, including what we've just been talking about. We also have some immigration laws that prohibit discrimination. One of the things that I should explain about these slides is a lot of our slides use the term illegal aliens because that's what the statutes say, but that's not actually correct. A lot of folks actually are legally here, but they're undocumented, or we want to say foreign nationals. So please know that's because we're quoting the statute, not because we're not using the correct terminology. So these are all things that the Department of Justice has the ability to investigate and also the ability to decide to sue you. Citizenship status, immigration status, national origin and retaliation. Some of those fall under Title VII, which are our anti-discrimination statutes, but there's anti-retaliation provisions in our immigration laws as well. E-Verify violations, when it raises to the when you don't enter into something to go ahead and pay it, that's where the teeth are because they can sue you to get you to pay it, and then of course that becomes public. unfair documented practices. We're going to talk a little bit more later about what that means. But that basically means that you are asking for documents to prove that somebody has the ability to work in the United States that in fact you cannot ask for. Or you're requiring certain documents as opposed to others. And then of course, and I say of course because if any employer doesn't understand that every statute on the face of the planet having to do with employment has an anti-retaliation provision, this one does as well. How does this process work? It's complaint driven. As Davis said, you can call an 800 number. I went to the website last night. They have a very easy to follow online complaint. Remember that just because you're an undocumented worker, you are still protected from all other employment laws, and it reminds you of that if you're somebody who's going to go ahead and file this claim. Then the investigators can come in and demand to interview witnesses. They can ask for discovery. That's where, hey, give me your documents. Hey, let me talk to people. They can enter into a settlement. Settlements can include things like, I call it the government is going to be your best friend for the next year or more. That they can have training requirements. They can make you post things in your workplace that says you are a violator of immigration laws and mea culpa, I'm a bad person. Your employees are going to see that every day. They have the ability to fine you, which we talked about, and compliance monitoring. That's what I really mean when the government's going to be your friend. They can require that you voluntarily submit documents, that you check in with them about training, that they get to interview your workforce to ask how people are feeling about working there. And your employees can sue you too. So if the government decides that something unfair has occurred, and this is something that they can decide in the course of just an I-9 audit, it's not the scary person coming with the search warrant that says, give me all your documents now. This can just be in the course of a regular investigation. Then they can take all these corrective actions, which could include corrective actions as applied to the employee. They can say you have to rehire somebody if you discriminated. Again, we talked about posting, we talked about education. There's even more. I had to make it 2 slides. You have the pleasure of paying the other side's attorney's fees. You're going to have a civil monetary penalty, and you're going to have to maybe even remove information from somebody's personnel file. So like if you gave a warning to an employee and it's proved that that was discrimination based on their documentation status, you're going to have to take that out. And then Title VII, that's the anti-discrimination statute. So remember, that has everything like emotional distress on top of back pay and front pay. So if you engage in national origin discrimination, you have the pleasure of paying the other side's attorney's fees, you have the pleasure of paying your own attorney's fees, you have the pleasure of paying front pay, back pay, emotional distress, oh, and then all those other costs we forgot about too. Depositions, court filings, and all of that. These are big money items. Here's a big one that both Davis and I think is going to come up more. Under the Immigration Reform and Control Act, an employer cannot knowingly hire an undocumented worker or continue employing that person if you should have known that person's unauthorized to work. That's what the lawyers call constructive notice. You may not have actually known when I get you on the phone, but when we talk about the circumstances, there's pretty good indication that you should have. Let me give you an example. I had a client, probably about 20 years ago now, who had a temporary staffing agency. And they counted on that temporary staffing agency to vet everybody's authority to work in the United States and check their social security numbers. And their temporary staffing agency gave them a call and said, hey folks, we just did an audit and we just found out that 70% of the people we were sending to your location actually had false social security numbers. And you're nodding because oops. So what happened was our client said, gosh, that's a problem because now I don't have people to do my work in the warehouse. That's what this happened to be. It wasn't a hospitality association. But then all of those people went and applied for work through a different staffing agency, and my client went ahead and hired him through the different staffing agency, saying that they didn't know. And we had to talk about, no, you should have known. That's a really clear example, right? So I fired Davis yesterday because I find out he doesn't have any documentation, and then he shows up through another temporary staffing agency the next day, and I still go ahead and continue to employ him. That's going to be a problem. I can't blame somebody else for that. But the should have known comes into play with I-9 documentation, right? If you're not looking at it right, if you're not making the right decisions about what people what documents they're giving you. If you don't have people trained, that's where mistakes like that are going to happen, and you're going to get caught for it. Look, there's fines and they're scary. Do I need to say more about the slide? All right, have we worried you enough? Let's talk about some proactive measures to protect your business. So as Davis said, I think it was one of the first sentences he says, you want procedures, not only if a warrant is presented, but if you get one of those notices of inspection. And remember, they're two different things. A notice of inspection doesn't have to have a search warrant with it. Doesn't even have to have a subpoena. If your ICE people come in with a search warrant, though, that's a bigger deal, right? That means there's suspicion of criminal activity, and you're not going to get that notice and flexibility area like you thought you would. You want to be sure your supervisors know who that first phone call or text should be. As Davis said, have them sit in a conference room while you say, let me go get you the right person to help you out. You're going to want a person on point to help with the documentation. Prepare employees for a possible raid. I'm not even really sure. We're not going to tell people they might get raided at any second, but we're going to tell people that we're compliant, that we're going to do training about anti-discrimination. We're going to talk about how we care about keeping our documentation, and then that is the environment that we have at our workplace. I think that's more what you need to talk about. But if you find that there's been some things in the news, you may actually need to have a meeting with your workforce to talk about what an inspection means. And depending on how serious the situation is, I hope you all know somebody you could call to help you with some PR. You might have to address the media. So it's all about, the I-9 is one of the easiest low-hanging fruits that our clients can get correct. And it's one of the easiest things to make mistakes about. And Davis is going to walk you through some common errors in I-9s.
Okay, so the I-9 form, again, it's a 2-page form now. The old form used to be 1 page. Section 1, completed by the employee. You never touch Section 1 unless you're a preparer or translator. That's the first rule. Second part of Section 1, has to be done by the first date of employment or after offer and acceptance. If you do it before offer and acceptance, you could be found to have potentially done a discriminatory act. Section 2, that's where you verify the information in Section 1. That's where you take the List A and List B and List C documentation to confirm that someone actually is work authorized in the United States. The one thing that I worry about with employers, though, is that they think that, well, the employee made a mistake in Section 1, and either they try to correct it, which is clearly unauthorized or you're not allowed to do it. But the other thing, too, is they say, well, that was their mistake. The employee is never sanctioned. It's the employer who's sanctioned. So if they check off citizen and they present a green card, well, that's on you. That's on you making sure that the information in Section 1 and Section 2 are consistent.
But wait a minute, that's on me how?
They'll sanction you, not the employee.
Fine, but how do I correct it if I can't make the correction?
Well, then you tell the employee to come back in and make the correction, or you make sure at the time that they're completing the form, you just take a couple extra minutes to make sure that the information is consistent. There are 2 sections in the form that you can mark N/A, and you're required to mark N/A, and it's highly annoying, but it's the email and the phone number of the foreign national. That is a technical mistake if you leave that blank. Now, you can't guide the employee saying, please mark NA. They have their options. But the only reason why ICE would ever want their phone number and their email address is to contact them, to see if, have you been discriminated against? Are there patterns of discrimination going on? Does this worksite have a lot of problems with unauthorized aliens? Yes?
I understood that the NA, at least on Section 2, is only required when a computer is used to complete the form.
NA I'm talking about in Section 1.
Section 1.
Yeah, the email and the phone number. Social Security numbers, you could leave blank unless you're on E-Verify. Then you have to complete them. So this is what Section 1 looks like. Almost everything above in that first set of boxes, if you miss something, it's a technical error. But see these 4 boxes here: citizen, non-citizen, national, lawful permanent resident, and alien authorized to work. if you fail to have the foreign national check one of those boxes, that's a substantive error. And if they come in and they find out that you did it, well, then you've submitted yourself to sanctions. The employee signature and date. The reason why that's important is that if you do that late, it is not correctable. There's nothing you could do to correct it. But let's say that you do your audit and you realize, hey, I didn't have them check off one of those numbers, or if I didn't have them complete the top boxes correctly. You could correct those, and there's no sanction if you do it. There is actually really good information on the INS webpage, or sorry, USCIS webpage. It's called I-9 Central. And this has continued to be built as a knowledge library. One of my favorite things is the I-9 handbook is actually now available as a searchable document. And I believe this is all available for all the members of the Hospitality Association. One of the things that I'm going to do is make sure we broadcast the next time we have an I-9 workshop. Just how do you complete I-9s? And it'll be a webinar. Again, this is a blown up section of what we have there. And this is what it looks like when it's properly completed. The reason why I highlight this is, you see how this is checked off, an alien authorized to work? And then there's a date there. If you continue to employ that person after the date, you've subjected yourself to knowingly employing somebody without documentation. That's the problem. So I had another farm where someone got her green card, but for 3 months didn't have work authorization. And what we got was a pretty substantial fine, but later we got a notice from the Office of Acquisition Management, which is the office that establishes federal contracts, and they said, because you continue to employ that person for 3 months and you should have known, we're going to ban you for federal contracts for a year. Luckily, that company didn't care about federal contracts, but if you're a federal contractor, that could shut down your business. If someone doesn't speak English or has some other disability, this is how you complete the preparer or translator section. One of the things that's really interesting is there is a Spanish version of the I-9 form. Has anyone ever seen this before? But the rule is you have to be in Puerto Rico to use it. So it's another one of those little traps, right? So if you're not in Puerto Rico, you can't use this perfectly good translation of the I-9 form. So you actually have to use the preparer translator section if you're translating it for somebody. So again, employee must complete. If they don't complete it after the first day, it's not correctable. You're going to get sanctioned for it. You do it 100 times for 100 employees, you got $100,000 you got $200,000 in sanctions. And it's really hard to push those down because it's systematic failure. Yes.
And when you say correctable, it means the employee needs to come in and make the correction.
Yes.
And they can just
Initial and date the correction,
initial and date, right?
except the lateness of the form. That's the one that you just really can't do. The Social Security number, again, not required unless you're using E-Verify. Employee did not sign a date is correctable if they can recall the date they did it. So let's say that you did the form and you always hire on Monday. And then on Friday you looked at it again, you go, oh gosh, they forgot to sign a date. You can have them come in and put in the original date they signed. This is the one circumstance they could backdate. But then they have to initial and date the correction and say why they made the correction. So personal recollection, I did this on this date. It becomes really hard if it's like a year later. That's why I'm saying make those corrections right away. Try to take the extra 5 minutes to make sure the I-9 is done right. What I usually tell people who are managers who are doing this is just think about it as $2,000 per form if you do this too fast. And it's really hard when you're doing like 20 hires in one day. But that short little stop really helps. This is section 2. The box that everyone misses is the very top box. The name and date and citizenship immigration status. That's actually new on the new form. The reason why that's there is it's reminding you to check what the person did in section 1, and also because it's a 2-page form, it connects the two documents together. So you can see how that relates to this. This is from section 1. What does it mean when you look at the documents? It has to be genuine and relate to the person. This is new. So if you have someone who has an old green card, and I think there's an example of this, right there, that no longer resembles the person anymore. That's not acceptable anymore. It used to be acceptable. So what happens if you get the family photograph and you have 2 people in the driver's license? You know, I used to throw up the McLovin driver's license. For those of you who are a little older, you might get that joke. But you know, if it's something that's clearly fake, then you cannot use it. Now, this brings up a really good question, though. Should you make copies of the documentation used to support the I-9? That's a question that I get almost every time. It is your option whether to do it, but you must be consistent. Catherine, can I drink this water?
Yeah, go ahead.
My throat. Sorry, I have a little bit of a cough. So, I get this question all the time. For E-Verify, there is a photo ID requirement that you upload into the system. But for everybody else who doesn't do E-Verify, should you make copies? My answer is generally no. And here's why. Unless you're going to do it perfectly, it preserves evidence that you did a bad job, or it preserves evidence that you did it inconsistently. So when I first started doing this, I had this lovely elderly HR manager down in southern Washington, and she goes, I don't need your help. I'm really good with my I-9s. And I said, great. Tell me a little bit about your process. She goes, well, first of all, any Latino name, I check all forms of identification, A, B, and C. Okay. And she makes copies only for the Latinos. So if you're doing it inconsistently, there's actually a possibility that you could accidentally discriminate. Here's another example. I did a large restaurant chain. Front of the house, the servers, tend to be done by the front of the house manager. The kitchen staff was done by the head of the kitchen staff. The populations were really different. So if the kitchen staff person is doing something wrong and the front of the house is doing something different, it could look like discrimination. It'd be really easy to actually make that assertion. For example, if they're done really poorly and they're not completed right, they may be saying you're intentionally avoiding detection by not doing the I-9 properly. Or if they're doing it too much, they might say, hey, you're discriminating against a certain population who's working in the back. So this is a good example of a really tough I-9. It says here, documentation, foreign passport. Now, I can't tell you how many times I've seen someone just put passport, and it's a Mexican passport, a Canadian passport. Even though List A is supposed to be a single column, you may have to do multiple documents. And here's the easy way to understand it. It's really amazing when you actually just read the form and the instructions. Under List A, it says identity and employment authorization. It is either a document or a collection of documents that establishes both the ability to work and who you are. List B is only identity, and List C is only employment authorization. So when you have a List A document, like a US passport or a US permanent residence card, it establishes both identity and the ability to work. List B, a driver's license, is really typical. That establishes who you are. And List C, such as a Social Security card that's not restricted, or a restricted Social Security card says valid only with USCIS authorization or something similar to that. Well, that could be used as List C in collaboration with List B. But here's another good example of why you don't make a copy. If you make a copy and it shows a restricted Social Security card, you just showed the government, hey, you accepted a document that wasn't acceptable. Now, why would you make copies of everything? Well, if you make copies of everything and something is wrong in the form, you could theoretically use the copy to make corrections on Section 2. That's a very small advantage. And I haven't seen ICE give anyone more favor or lower their fines because they made copies. It's almost always the other way around. The copies reveal a liability. So remember, it's either a list A or a combination of list B and C. I don't know if it comes up later in the slides, but I'm going to tell you something else too. Do you re-verify somebody who is a permanent resident when their permanent residence card expires? No. Why is that the case? Because they're still permanent residents. It's just like a citizen showing their passport. Just because your passport expires doesn't mean you're not a citizen anymore. Your document has to be current at the time it's executed, but you do not re-verify permanent residence. That's discriminatory behavior, and in California, that could be $10,000 per instance. So for those of you who have California locations, you may want to make sure the California people are really closely in tune as to what's going on. Yes?
Now, they use that on section 1 and they put the expiration date on section 1 and you have to check it if it's in section 1.
Are you talking about the expiration date of a permanent residence card?
Yeah.
So the expiration date of a permanent residence card doesn't go in there. I'm just going to go right back in here. It says lawful permanent resident. It says the registration number, not the date. So their work authorization doesn't actually expire.
But so if they put the registration number there and then I think the old form used to have a place where you have to put an expiration date.
Not for a permanent residence card. But the new form, and all the old forms in addition, if you put in the list A document, it says the expiration date of the document. And that's just to make sure that it's valid as of that date. So if it expires tomorrow, it's perfectly valid. So here are the common mistakes that we see in section 2. No start date listed in terms of the certification box. Well, that's pretty easy, right? You can just go back to your payroll records to see what the first date of hire is. You can make that correction. And remember, section 2, you could do all those corrections, but sometimes you have to call the employee back. For example, you forgot to take list A or list B and C is empty. Well, then you have to call them back and say, look, I need to see your documents. I need to get this done right. The issuing authority, document number, or expiration date is missing. One of the things that I see all the time is WDL. And people say Washington driver's license. That could be Wyoming. It could be Wisconsin. It's a technical error. They allow you to make that correction, but why put yourself through it? Use the 2-letter abbreviation or any commonly accepted abbreviation. Social Security number can be SSN. I'm fine with that. SSA could be the Social Security Administration. That's fine. Too many or too few documents in list A, B, and C is a really common error. Not too worried about that at all. What you could do, though, is you could correct that upon audit. So the corrections of the documents, we've identified well over 100 different corrections that could be made. So I can't give you like the list of all the corrections that you make. Just remember a few core elements. Every time you touch it, try to use a different color ink. That way you could establish what the evidence trail is. Like, this is the correction that was being made. Initial and date it, and if it isn't obvious, write on the margin. Made this because I forgot the document the first time or discovered upon audit, whatever that is. But you must initial and date every correction. And also remember, if it's section 1, the employee has to touch that section of the form. The other thing that we see all the time is the signature date and the signature box is incomplete. They just, for some reason, you do this beautiful job on the form and you forget to sign it. Signatures can be corrected if you're the person who did it, because you're certifying that you actually looked at the documents in person. The date, again, if you have personal recollection that, hey, I did that on that date, it was my birthday, so I remember, something like that, you could write that in. Re-verification applies to people who have expiring work authorization documents. That's that EAD card, including DACA work authorization cards. Some of those cards allow for automatic revalidation, but this is where the employer gets really stuck in the middle. You don't know which cards come with automatic extensions or not. The vast majority of them do not, but if you stop someone from working and they actually had proper work authorization, they have a claim. This is an interesting question about new names or names that are different. So I changed my name when I was 18. It used to be David. My Social Security card still says David. If I was to use that document, it actually allows for nicknames. So if you're John and your legal document says Jonathan, That's perfectly fine if you completed your I-9 with John. But we're seeing this more and more about transgender cases. And this is where it goes right back to Catherine, right? Is that someone says, hey, my legal document says Teresa, but I want you to call me Terry or John or whatever it might be. And they're really insistent on it. And then you have to make a decision. Do I want to really deal with plaintiff's counsel or do I want to deal with ICE? If the document that they're providing reasonably associates them, you can write on the margin saying, employee insisted on filling out the I-9 as something else. It's a lot easier than dealing with plaintiff's counsel who's saying, you know, all these factors are another indication of discrimination. So here are some examples. This is the classic work authorization card. This is an immigrant visa. You're not going to see those too often, although you might if people are leaving and coming back and getting their green cards. But this is what you should be expecting. They change all the time, by the way. So that's another problem for employers, right? If you make a copy and something is clearly wrong, well, they could say to you, you should have known that that was an expired version of the document. If you don't make a copy, there's no way for ICE to accuse you of should have knowing. And green cards aren't green for a while. For a while, they came out pink, and then they moved back to green. So this is an example of a properly completed re-verification or rehire. Interestingly enough, you don't need the foreign national to come back for this part. But it's always worthwhile to just read the instructions again as to what you are certifying. And one of the places that I really like people to read is this one. This is where the personal liability comes up. I certify under the penalty of perjury that I have examined the document presented by the person, that the above listed document appears to be genuine and relate to the person, and to the best of my knowledge, the employee is authorized to work in the United States. That's the known or should have known language. If someone walks up to you and goes, here's my fake green card because my old one expired, you can't accept it. We talked about this, not relating. This is not government ID. Here's that language that's restricted, valid only with INS authorization. Anything that says something similar to that means that it is not a Social Security card for purposes of I-9 verification. This is just destroyed. You can't tell what that is. So what do you do when someone says, hey, that's my Social Security card? And they meet, multiple categories of protected class. And you don't want to really tell them, well, I can't accept it. But in this case, and we could help you with this language, this is where you say, unfortunately, it doesn't meet the standards of the I-9 document because it's damaged, or I can't tell what it is, and I can't tell if it's genuine or not. So here are the common errors in Section 3. And again, 95% of your I-9s aren't going to have Section 3 corrections. And by the way, changing a name is only optional now. You don't have to do that every time someone changes the name. So a lot of people who get married or divorced, that question comes up quite a bit. Date of rehire, this is for people who are seasonal or rehiring. There's certain rules for that. It's really complicated. I recommend you go look at the M274, which is the handbook, or I-9 Central about seasonal hiring or rehires. But for the most part, you won't have to do Section 3. If you do use Section 3, just be sure that you're using it correctly. A lot of people will re-verify people that you don't have to re-verify. So again, do not re-verify people who are permanent residents. They're still permanent residents even though their documentation has expired. As of April 2009, some expiring documents may not be accepted. That's a really tough one. You have to really go back to actually looking at the document, putting it into the I-9 Central. There's a search box, and you'll find out all sorts of information about that particular document. When you actually ask for documents, remember, it is up to them to select what documents to present. So this is an important note for people who have someone else who backs them up, right? I mean, hiring happens all year. If you go away for a vacation and you're still hiring and the Next person comes up and says, look, I can only look at driver's licenses and social security cards because that's all I know. You're violating the I-9 rules, right? So make sure there's at least 2 people who know how to do this properly. And again, a restricted social security card isn't a social security card for purposes of I-9s. This is a fun rule about how long do you keep I-9s. And I'm going to give you a tip that doesn't exist within I-9 Central. You must keep it for 3 years from the date of hire or 1 year from the date of termination, whichever is longer. And there's a fairly simple chart within the M274 where you put in both dates and then it says this is your destruction date. If you have problems with this, I frequently tell people that once someone concludes employment, calculate the date that you could destroy that document. The longer you hold on to it, the more the liability exists, especially if you do it wrong. So think of it this way. Your I-9s, by the way, should be in a protected area of your worksite, right? There's lots of private information in there. You don't want it exposed. But you keep that alphabetically according to all your current employees. So it's your current employee binder if you want to use a really simple method. Once they terminate employment, move it to the termination binder, which is not alphabetical, but it's in the order of the date that you could destroy the documents. And you sweep through it once a month, once a quarter, whatever your period that you feel like you have the time to do it. But that way, when ICE comes in and they say we want all the active employees, you're not trying to sit there and figure out which ones have already been terminated, which ones I shouldn't have to submit. That's what I've always found to be the most effective way to do that. The photocopy rule, I think I've beaten that to death. Again, I would typically tell employers, unless you're going to do a fantastic job, don't do it. If you're going to do the corrections, remember employees have to do Section 1, employers have to do Section 2. Every change has to be initialed and dated. And if you want to make it easier for the examiner, and I will say that does save you a lot of money. If you make it easier for the auditor, do it in a different color ink. Even if you did it wrong and acknowledge that the mistake is there, I have seen auditors say, thank you, you just made my job a lot easier. So that's where you say per self-audit. If you see that you've done it late, just make that notation. So that's actually a pretty good correction. That's over documentation. Yes?
So if I'm going through employee files and discover that there's one that does not have an I-9, what is the protocol for moving forward? Can we fill that on the spot, or what are the rules surrounding that?
Okay, so we could talk about in the Q&A specific examples, so that's a good one. So you're going through your I-9 audit and you just can't find one. You call the employee in, you apologize, hey, we need to comply with our government files. For whatever reason, we can't find yours. Would you mind if we redid it again? You do it as of that date, and it's a late form, but at least when the officer comes in and they say, hey, this is a late form, they go, well, that was the correction we would have told you to make anyway. You know, thank you for that. And if you have a small error rate, it might actually help you.
The next slide might be that. There you go.
Okay, so, oh, there you go.
That's me.
Yeah, so here, I'll turn it back over to Catherine.
All right, so I hinted about unfair document practices earlier, and Davis has been talking about them throughout because this is one of the areas that you can get hit with a discrimination claim in whatever venue or in whatever manner it's coming up. So if you say we only accept Social Security cards and driver's license, that is an unfair document practice. Davis's example about the back of the house and the front of the house, doing the I-9s differently potentially or looking at different documents is a huge red flag for a problem. Asking for extra documents, back to Davis's example that he gave earlier about the woman who said everybody with a Hispanic name she asked for extra documents for. I heard everybody in the room moan, so that's good. I don't need to advise you on that. The employee does have a choice with which form of the acceptable documents they're going to give you. So if your folks aren't trained up on how to spot whether those are genuine or not, that's a to-do item for as soon as you head back to the office. We've beat the money to death, but here's another slide about it. By the way, if anybody wants copies of these slides, just give us your card after the presentation and we'll email you a copy of it. I promise we won't bug you or put you on a bunch of mailing lists, but you're more than welcome to get a copy. We talked about how we determine penalty amounts. Again, that good faith effort to comply, which is one of the reasons why this self-audit can be such a valuable tool. And then we're going to look about the seriousness of the violation and the size of business in your history again. We already talked about these slides. Criminal penalties, again, just in case we forgot, we can get into this problem too where you have to go to jail, or what was it, Davis, pay how much money that first guy?
That was $1 million.
Yeah, it was $1 million. All right. Civil violations of the immigration reform under ICRA, let's just say it this way. Remember, we said knowingly hire an alien, hire any individual without verifying identity, and in continuing to employ people when you should have known. I talked about the third one already. Let's talk about the second bullet. Hire any individual without verifying identity and work authorization. Assume the government will decide that the reason that you failed to get somebody's paperwork is because you suspected they were undocumented or here illegally. That's what the government will assume. Even if it's just a mistake and you lost the form or you forgot to ask that day or it was so busy you needed somebody to start work, that is what you're going to have an uphill battle to prove that that was just an error. So let's not do it. Red flags. I gave you this slide because it actually has to do with some red flags that might come from the employee. And when you have red flags like that, again, the government might assume that you had constructive knowledge that you were hiring somebody that was undocumented. So if the employee asks for help, how do I get a social security card? It's a pretty big red flag. And by the way, to Davis's point, questions like this, we are always concerned about discrimination and national origin discrimination or immigration discrimination. But when the questions specifically relate to something you need to fill out on the I-9, we have what's called a business necessity defense. Pretty clear, right? You can say, no, I had to ask that question because I had to lawfully complete the I-9 form. If you can tie it that closely, that that's the reason that you're asking, and you ask everybody for it, you treat everybody the same, you're going to be sitting in a good spot in terms of being able to defend yourself. Possible identity fraud. I mean, if that doesn't trigger an audit, I don't know what would. Right, Davis? Employee asks you to sign a document to get some sort of immigration benefit. Again, a red flag, and we should not do that. That's your free legal advice for today. An employee tells you about another employee using fake documents. What do we do, Davis? Do we audit the person that's been complained about? No. Or do we do it? What do we do?
Like, so someone's complaining about another employee?
Yeah.
So the one thing that this is a really tough one, because if it's an anonymous call, we say don't do anything. If it's specific about another employee using fake documents, I usually go back to the employee and say, someone has accused you of submitting fake documents. Do you have anything that you want to clarify with us? We are not saying that you actually do have any fake documents. We're just saying that you should be aware of them.
And maybe the first thing you do is take a look at that I-9 that you completed. So let's say I go to Davis and say I think David's using fake documents. Maybe the first thing Davis does is pull up David's file, and if you feel pretty good about what you looked at and you happen to have memory of that, maybe you don't need to have that talk about with the employee. But that's one where you might want to talk to counsel.
The one that's really curious is when you get a call from the East Coast and someone says, someone at your company is from a lawyer sometimes, is using my client's social security number. That's a really hard one. And again, I will go back to the employee and saying, I just want you to be aware that this has been stated about you. Now, if the employee goes, yeah, I'm fake, I don't have anything, well, now you have constructive knowledge, right? You have actually actual knowledge. But if the employee's like, I have no idea what that's about, I've been getting these weird calls before, I'm a victim of identity theft, well, then you leave it alone.
Yeah. I had a case once where actually a newspaper picked up that the employee was using a fake social security number. The employee happened to be high-ranking enough in the company that they thought it was a newsworthy event, and the newspaper interviewed literally the poor little old lady whose social security number it was, and that went in the newspaper. So in that situation, we did advise to talk to the employee who had presented that social security card and have a discussion with about it, because I think you would be in danger of the knowingly to continue to employ him at that point. I was not worried about the discrimination claim. So a couple things that come up in reactions to these kinds of trainings is, well, I'm just going to ask everybody to tell me that they're a documented worker before they even apply for the job. We had a gentleman that asked about running E-Verify, which we can't do. You can say something in recruitment and ads, though. This is an example of a lawful phrase. Unrestricted authorization to work in the U.S. required. That's lawful. You can say that. You can't ask about specific immigration status until after you make an offer, but you can make a conditional offer. We're used to that in the ADA realm, right? If we're going to have somebody, maybe even we do it for drug testing, even though drug testing is an example, right? I'm going to make you this offer, but it's contingent on passing your drug test. This offer is contingent on you having documentation that you can work in the United States. The other question I often get is, well, I'm just going to change my interview questions then so I can try to weed out folks in my interview process to try to spot these issues. That's probably going to violate an anti-discrimination law. So you can ask, do you have unrestricted authorization to work in the United States? That's an okay question, just the same thing we put on our recruitment. You can't say, where are you from? Does everybody know that? You can't say that even though it's something you would say maybe in everyday conversation, because it potentially could elicit an answer about somebody's national origin. That has nothing to do with discrimination, actually. That's unlawful under Title VII. You also can't ask, when did you move to the United States? Can't do it. I rarely get to say there's something that's so black and white in employment law, but these are a couple of them. You can make the offer contingent on the work authorization, which is what we just talked about. So what is our planning and recommendations? Well, we've talked about them throughout today. This is really just a summary slide. You want to know what your worksite compliance policies are? You want to have somebody who's in charge of that? As Davis said, he used to not be such a fan of E-Verify, but that's changed. Think about doing it sooner rather than later. Be sure that whoever is doing your I-9s is getting training. And maybe it's not, I just count on them to be up on all of these things. Might want to check with those folks a little bit more. This doesn't have to be expensive or necessarily coming to a webinar put on by Fisher Phillips. There's a lot on the website that's free. We didn't talk about visas today. That doesn't really apply. Prevailing wage requests, I don't think that's something that you all need to worry about. So, how's that? I went pretty fast. Thank you all for coming, but we're happy to take questions about anything now.
Do you want to plug the seminar real fast?
Yeah, well, I did that last.
Okay.
Yeah, David.
So I would be completing paperwork with an individual who had a very strong, quote, Australian accent, and he or she fills out on the form U.S. citizen and provides a driver's license or social security card, and they may not be that. How do I get?
You may not be what?
They may not be a U.S. citizen. How do I, like, they have a strong Australian accent.
Oh, I see.
Obviously
So
not from America.
So based upon their accent, you're saying they marked citizen, they gave a driver's license and social security card that's perfectly unrestricted. Do I have a duty or should I be questioning that? And the answer is no. What you want to do is...
Now, when the audit comes through and they find out that it's fake, and based on what I observed not to be fake,
your job is not to be an expert. Your job is to just do the minimum required by the I-9, which is, was it genuine? Did it relate to the person? And if you have both of those things, you are free of liability. You are not responsible for people giving you beautiful fake documents. There's almost nothing you could do unless you do E-Verify to detect whether someone's work authorization is fake. There are some amazing looking fake documents. There's also some really bad ones. But yeah.
I am also happy to defend you and say, we don't profile based on accents here at my job. That's not what we do. In fact, you guys don't want us to do that, right? Sounds pretty good. We don't profile by how somebody looked and their accent. And I haven't heard of a case yet where that was enough to catch you with a constructive knowledge. I'd like to think we'd have a defense. Anything else? Yeah.
I remember, gosh, probably 8 years ago when ICE was really strong with the Obama administration, and we actually had ICE agents come to all our hotel front desks and were passing out seminars that they were doing. And
Yeah.
it was pretty gruff. But what we discovered through that process is that there weren't a lot of ICE agents, frankly, in the state of Washington for Morisset. I think maybe 4. And so I'm just curious, do you know the number of ICE agents that would conduct these audits in our state?
There are forensic accountants who do this. One just retired. I think there's 3 or 4 of them still. What happened, what you saw, was when Obama initiated the ICE investigations, he also put a lot of money into education. Because what he really wanted was corrective behavior. So you saw a lot of those free seminars. We actually co-paneled with ICE because we were happy to make sure. The problem with the free seminars was it was just the most basic information. It doesn't talk about the complicated nuances. And if you ask the ICE office, they're like, well, you got to go ask your counsel. You know, the circumstance of I got a call from the East Coast, someone says this person's document is fake. Well, ICE isn't going to tell you whether you should investigate that or not, or what the employment consequences of that are not.
Yeah, and to answer your question, I don't know the answer to that question of the exact number. If we can find out, lend me your card, I'll drop you a note. I do know they got their appropriations to hire more. So this statement about we're going to quadruple our audits means nothing unless they hire a bunch of people. Davis and I were just talking about, I mean, they are having problems recruiting. A lot of folks who have this focus they want to talk about human trafficking. They don't want to talk about I-9s. So, you know, I think maybe the real point of your question is this a lot of bluster with no teeth to it? And I think that we can't assume that's going to be the case. I think particularly with this administration, they're going to get the money. They already did. And whether there's even, you know, this is where I always talk about let's practical versus political. I mean, one of the things that President Obama's administration showed is that they were able to get a lot of money for the government by doing these audits. So are people going to give that up? I'm going to think not.
And then, do you know of any ICE raids in hotels, this is a hotel conference, in the state of Washington?
I haven't personally had one come to me in a while, but I have done hotel raids in Washington State several times. It's been about a year since I've seen one in the hotel industry. The number of audits hasn't increased since Obama came in. The intensity has, like how they investigate the sanctions, their flexibility, but I do expect it to go up. And it's really early in this administration. I don't even know if those figures are in yet.
So back to the initial, when they come in and they have the warrant, do you still have the 3 days or you don't?
If it's a notice of inspection of documents, it's a 3-day period. If it's a search warrant, the thing about the search warrant where they're looking for a specific individual, they had to go to a judge for that who has to determine if it's overly broad, if it's appropriate. And in that case, I think you have to comply. The only thing you want to do is call your counsel right away and say this is happening.
I think one question you've had a lot is this a search warrant or is this a notice of inspection?
And it actually says it right on the cover.
Often something that it should say it right on the cover.
We actually had one probably about 6 years ago where ICE did come in, and it was no different, I guess, if someone wants to do an arrest, you know, on your property, and we cooperated, and it was actually a very surprising individual that we never would have guessed in a million years.
Yeah.
So,
And that was for just one person, the target of the warrant.
It wasn't in housekeeping or kitchen or where you would traditionally, I guess, stereotype. It was not at all, so. And he ended up being deported.
Yeah, I think one person would be easier to handle in terms of business disruption and morale issues too. I'm always worried about that. So I tend to really believe in employee transparency. I think that gets everybody far. I haven't heard any of Washington. I mean, we have colleagues on the East Coast who talk about, you know, when ICE will come in with a search warrant for several people at the same time, and that tends to make bigger.
Yeah, I work with a food service company, and I actually created a protocol because we knew that people in there would be undocumented. So if someone comes, you know, this is where they sit. They closed off all their extra access points so that ICE officers can come through a back door because they had multiple access points. Very simple, short. And then the people in the front, these are the people you call. This is how you handle it. And it was pretty effective.
Yeah. Yeah, go ahead.
I guess my question is, all of our information is held at our corporate office, so all of those files go through there, except that we as individuals sign off on that I-9. So are we the responsible party at that point because we signed off on that?
By signing off on it, you commit to that penalty of perjury. But on the other hand, though, in terms of if there's a fine for failure to do the I-9s that has nothing to do with, you know, you specifically trying to defraud the government, then that's going to go on the company. And also, it's perfectly fine for you to store the I-9s away from your facility if you have a corporate office. They just have to be available within 3 days.
The individual liability is going to come more into play when you're talking about the knowingly hire, although that probably will get imputed to the company. And then that very first slide that Davis had at the beginning where there were the 179 individuals who are arrested is in the course, that would be based on their signature on the particular form where the government would have assumed that there was more there to hold that particular individual accountable. Does that answer the question? Sandip.
This might be a tough one, and I know you don't work for the insurance industry necessarily, but is there insurance coverage, employer?
There was one so we're talking about EPLI?
Yeah.
Employer Practice Liability Insurance. It is not covered under EPLI. I heard of one insurance company that was trying to add it, and I don't think it went anywhere as a rider. But this is not covered by your EPLI.
Yeah, if it was an individual national origin discrimination claim, that traditionally is something that would fall under EPLI insurance, but not the big penalties and fines and criminal penalties that we're talking about. I've never seen it covered. That doesn't mean it hasn't been. Any other questions we can answer? Yeah.
Might be kind of a stupid question, but if we are presented with documents that are just completely false, are we required to do something other than not hire them? Are we required to report? Is
No.
there any type of other type
Yeah, so you have no obligation to report to the government. The only thing that you have is just you can't use that document as a form for the I-9.
Or ignore it and hire them anyway. Yeah. Sometimes we have to say the obvious things. Yeah.
Can I ask 2 questions?
Of course you can.
You were showing us the updated version of the I-9.
Uh-huh.
Do you know when that?
July.
This year?
Yeah.
September, I thought it
Oh,
was.
is it September?
September
I'm sorry.
28th.
It's on the website.
Oh, it was announced in July, I think.
Yeah,
and
it was announced in July and it went in.
Yeah.
September 14th.
It was actually just a few months, like 8 months after the previous one, which is really funny. Yeah.
September 18th, 2017.
But I think it was like announced in July that they were coming out with it again.
Yes, they actually did give warning.
My second question, if you have been practicing like making the copies all this time, would you revert back and?
Yeah, what I would do is, and I've had this question come up, especially when the people have found out they're doing it inconsistently, is I would go through and do an audit or at least a review of your procedures and say, as of January 1st, 2018, we will no longer be keeping copies of Form I-9s. You could also talk about like other changes you're making to the process, and then just be consistent after that.
Well, you want to keep Catharine informed, right, but not the documentation presented.
Yeah, of course. You keep the I-9, just not the supporting documentation.
That's what I meant.
Yeah,
Yeah.
you said the form. Yeah.
Oh, I'm sorry. And then the other thing too is, if you have specific questions, I'm going to stick around for a while, and I could answer any like specific company questions.
Security mismatch letters, do they do those anymore? I haven't seen them.
They're supposed to be coming back. So the question is, Social Security mismatch letters were common a long time ago, and now we haven't seen them in a long time. The one thing about Social Security numbers, and I just want to make sure everyone understands this, is that a Social Security mismatch does not necessarily mean that someone doesn't have status in the United States. There's a lot of case law to support that, but we expect it to come back. You do have an obligation to review a Social Security mismatch, but it is not an immigration status question.
Another question?
So if you have a company that actually does a background check of everything that you've done, are they doing the e-verifying or are we supposed to do it?
You'll be doing the e-verify for your own employees. They wouldn't have the right to get into the system because you have to be an employee of the company. You can make someone like me an administrator to make sure you're doing it right, but I do not execute the e-verify for you. Co-employment's a little different. For those of you who use a co-employer, then you may have a situation where you're not responsible for the e-verify or the I-9s because it's done by the co-employer.
And if you're a co-employer or a joint employer, like that example I gave earlier about the temporary staffing agency, you should have your lawyer absolutely look at the contract between you two and make sure there's an indemnity clause in there, which means if they screw up, they have to pay most of it. Although in the end, even trying to have somebody else do all of your checking for you if it turns out that one of your supervisors has knowledge that you are knowingly employing somebody who's undocumented, it's not going to save you that you have the other company do the I-9 check. We'll stay after. I feel like we should let you go. If anybody's interested in more employment law stuff, we do our annual seminar every year. December 5th is when it's going to be. It's complimentary. I gave you some information. If you want copies of the slides, please give us your card. We're happy to send them to you. And thanks for your attention.
Yeah.